In the first part of series Basics of Criminal Trial, we will discuss the types of offences. In this, we will discuss what are cognisable offences and non-cognisable offences, what are bailable and non-bailable offences, and what are compoundable and non-compoundable offences. Cognisable offences are the ones in which police officer has a power to arrest a person without warrant. As these offences are of more serious nature, the court permission is not required for the investigation or arrest in such cases. Further, there is substantial police investment in the investigation and the collection of evidence if it is shown that the cognizable offense is committed. Now let's discuss what are non-cognizable offenses. In these offenses, police officer has no power to arrest a person without warrant. As these offenses are of less serious nature, the court permission is required for the investigation or arrest if information shows the commission of non-cognizable offences. Further, there is no substantial police involvement in the investigation of non-cognizable offences. Now let's discuss what are compoundable and non-compoundable offences. Compoundable offences are the ones that can be compromised between the complainant and the accused, as only private parties are impacted. Now option has been given to the parties to settle their disputes amicably. In these offences, the complainant bona fidely agrees to take back the charges levied against the accused, which results in the acquittal of an accused. Now, compoundable offences are of two kinds. In the first kind, the court's permission is not required for the compounding of offence. For example, in offences of adultery, defamation, voluntarily causing hurt, court's permission is not required. Whereas in the second kind of offences, court permission is required. Offences like theft, criminal breach of trust, act done with intent to outrage the modesty of women can only be compounded after the court permission is granted. Now, what are non-compoundable offences? These offences are of serious nature and the parties are not allowed to compromise and the charges against the accused cannot be withdrawn. Even in this case, even the court has no power and authority to compound the offences. A full trial is held which ends either on the conviction or the acquittal of an accused based on the evidence adduced before the courts. As these offences affect both private parties and the public at large, therefore no compounding of offence is granted. For example, murder, rape, and death caused by act with intent to miscarriage, etc. are some of the examples of non-compoundable offences. Let's discuss what are bailable offences. Section 2C of the Bhartiya Nagrik Suraksha Sanhita defines bailable offences as those offences which is shown as bailable in the first schedule or which is made bailable by any other law for the time being enforced. In simple language, it can be said that in the bailable offences, bail can be granted as a matter of right. However, the person may still be required to furnish bail bond to ensure his presence at the trial. Bailable offences are relatively less serious offences which are punishable with imprisonment for a term of less than 3 years or with fine only. For example, offences of voyeurism, stalking, bigamy, etc. are bailable offences. Section 478 of Bhartiya Nagrik Suraksha Sanhita lays down the provision for bailable offence, which states that an accused person arrested or detained for bailable offence shall be released on bail if the accused furnish a bail bond with or without sureties. Now let's discuss what are non-bailable offences. Non-bailable offences are those where bail cannot be taken as a matter of right. In these cases, the court has a discretion to grant or refuse the bail. In such cases, the accused has to approach the court for bail and is required to furnish reason and provide sureties before the court consider bail application, as these are offences of more serious nature and thus are punishable with imprisonment for more than 3 years. For example, offences of murder, rape, dacoity, kidnapping, etc. Section 440 of Bhartiya Nagrik Suraksha Sanhita lays down the provision for bail in non-bailable offence, which states that an accused person arrested or detained for non-bailable offence shall not be released on bail unless the court believes that there are reasonable grounds for granting of bail. That's all for today. Thank you for watching the video. Please like, share and subscribe.